The separation of powers is an idea which is fundamental to how the UK works. It is about having specific and separate powers and functions between the three branches of state. This is supposed to help keep these three branches independent and accountable by making sure no one part is too powerful. The three branches of state are the legislature. The legislature makes the laws. In the UK, the legislature is Parliament, which is mainly the House of Commons, which MPs are elected to, and the House of Lords, which is made up of peers. Both the Houses of Parliament will debate proposals for laws, look at what changes should be made, and pass or reject laws. When a law is passed, the Crown, currently the Queen, gives it royal assent to make it official. This is ceremonial, as the monarch does not refuse to make laws passed by a Parliament official. Parliament also carries out scrutiny work, which involves examining and challenging the work of the government. This might be through debates, questions, or committees. We have devolution in the UK, so the legislature also includes the Scottish Parliament, the Welsh Parliament, and the Northern Ireland Assembly. These parliaments and assemblies have been given lawmaking powers by the Houses of Parliament. The Executive. The Executive is responsible for creating policy, putting proposals for laws to the legislature, and putting laws into effect. We call this the government. In devolved nations, Scotland, Wales and Northern Ireland, the executive includes the first ministers and governments of the devolved nations. The judiciary. The judiciary decides whether laws are being followed or if they've been made properly. This is done through a system of courts and tribunals. In the UK, the judiciary is made up of the judges and officers of the courts of law. These are overseen by the Supreme Court. The Supreme Court is the highest court in the UK. The courts in the UK can decide on conflicts between state bodies, between the state and individuals, and between individuals. In the UK, we have three legal systems, one each for England and Wales, Scotland, and Northern Ireland. The Supreme Court is the top court for all these systems. Why is the idea of separation of powers important? It is important that these branches of government are separate, so that one branch of government doesn't hold all or too much power. Each branch is therefore able to check on the other two branches to ensure that they are not overstepping their role. This means that there is a system of checks and balances. This should prevent each branch from abusing their power and helps ensure fairness in our system, making sure every part of the state has to play by the rules. How does this work in the UK? In the UK, we do not have a strict separation of powers. The branches of the state are closely linked. For example, the Prime Minister is both head of the executive, the government, and generally the leader of the majority party in the legislature, Parliament. This is because to form the government in the UK, a political party must win more local elections than other parties to have the most MPs. This means the leader of that party will be the head of the government, the Prime Minister, and will usually have the most MPs who can vote to pass laws in Parliament. There are still checks and balances in place to ensure that no branch of government has too much power. For example, the legislature can keep check on whether the executive is doing their job through things such as ministers' questions, debates, and investigations by committees. Prime Minister's questions is another example of this. The judiciary, courts, are independent of both the executive and the legislature. In the UK, judges are not elected, unlike in some other countries, so they're not accountable to voters. Judges are selected by the Judicial Appointments Commission based on their merit. They are independent. People can start a legal case and ask a judge to look at whether the right laws and processes have been followed or broken. This includes bringing cases that are about the actions or decisions of the executive or government. This type of case is usually a judicial review. Judicial review is a tool to examine whether decisions by public bodies have been made in a lawful way, using the correct processes. Judicial review is a very important process for protecting our human rights here in the UK. One of the reasons why a judge can find a decision of a public authority unlawful is if the decision is in breach of the Human Rights Act. If the judge finds that the decision breaches someone's human rights, it will be like the decision was never made, and the decision-making process will have to happen again. Judicial review, or the threat of judicial review, helps give our legally protected human rights teeth. It is part of what makes them enforceable. Judicial review means that people who feel like a decision made by a public authority has breached their human rights can challenge this. Really importantly, the potential that a person can bring a judicial review case encourages public authorities to use good decision-making processes in the first place.